Good afternoon, everyone. Thank you for joining us for today's online talk. We'll be starting shortly, so stay tuned. For those who are already here, we thank you for your patience. While waiting, we would like to share with you a short video from the firm.
I founded the firm in September 1985 with the vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on a bedrock of meticulous preparation and hard work, for which there is really no substitute. As legal practice becomes increasingly international, we keep ourselves ahead of the curve with our relationships with lawyers from around the world. Our firm is a founding member of the League of Lawyers, a growing international network of law firms in 20 Asian and European countries.
We believe in partnering with our clients to protect and grow their business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
Welcome, everybody. Thank you for joining us for today's online talk entitled AI in Business, Navigating Legal Risks and Compliance. My name is Amir Haris. I'm a pupil in Chambers with Ma Weng Kwai and Associates, and I will be a moderator for today's session. Before we start today's talk, let me introduce the firm and explain the work that we do. Ma Weng Kwai and Associates is a mid-sized law firm that was founded in 1985 by Dato' Ma Weng Kwai. Our able team today comprises 37 lawyers and a support team of 29 support staff. Dato' Ma himself is currently a consultant with the firm following his retirement from the Court of Appeal bench in 2015. Today, the firm continues its tradition of working primarily with SMEs, family businesses, and individuals. We are a full-service law firm with a corporate department, a dispute resolution department, which includes litigation, adjudication, and arbitration, a dedicated employment and industrial relations team, as well as a department focused on servicing the needs of individuals and families. Our practice groups indicate some of our focus areas as seen here, which are supported by great talents from both our corporate and dispute resolution teams. Today's talk is part of our MWKA online talk series. To give a bit of background, we have been organizing monthly lunch talks at our office since 2013, some of which were also broadcast live. But with the COVID-19 MCO, we have moved online in order to continue with our objective of sharing knowledge, raising awareness, and encouraging networking for clients, potential clients, and in-house counsel. Before I continue, please be reminded that this talk does not constitute legal advice. In the event that you require specific legal advice for any matter, please contact us for a complimentary legal consultation, details of which will be given at the end of this talk. Now we have 3 speakers for today's talk. Allow me to introduce them. First, we have Ms. Anis Mohammed Suhaimi, who is a senior associate in our corporate department and Sharia advisory department. She graduated with a Bachelor of Laws honors from International Islamic University of Malaysia and was admitted to the Malaysian bar in 2018. Her areas of practice include corporate advisory, commercial agreements, regulatory compliance, and mergers and acquisitions. Next, we have who is an associate in our corporate department. She graduated from the University of Malaya with a Bachelor of Honors in 2020. She was admitted to the High Court of Malaya in 2022, and she's primarily involved in corporate and commercial matters such as mergers and acquisitions, regulatory compliance, and drafting corporate agreements. Lastly, we have Ms. Sarah San, who is an associate in our corporate department. She graduated with a Bachelor of Laws honors from the University of Malaya in 2023, She was admitted as an African solicitor of the High Court in Malaya in September 2024, and her areas of practice include corporate and commercial matters, and experience in technology and intellectual property law, as well as esports law. Our main talk points for today are as follows. First is the legal framework for AI in business. This will be covered by our Ms. Mira. Secondly is accountability and liability in AI integration, which will be covered by Ms. Sarah. And lastly, mitigating AI risks, which will be covered by Ms. Anis. We will then conclude the talk at the end with a Q&A session where we will address any questions you may have. So if you do have any questions, please type it in the chat and we will address them at the end of the talk. Now, please allow me to pass the floor to Ms. Mira to begin our talk for today. Thank you.
Thank you, Amir. Good afternoon, everyone. Thank you, Amir, for the kind introduction. My name is Mira, and I'm an associate in the corporate department of Mao and Quine Associates. So for today, I will be the first speaker for today's talk, and I'll be discussing on the first talk point, which is the legal framework for AI in business. So with that being said, let me start. Now, before we delve into the specific legislations, frameworks in relation to AI, it is important for us to actually acknowledge how widespread is the usage of AI is now in our daily lives, especially in businesses. You see, with AI providing, delivering enhanced services and delivering accuracy and efficiency, it's no surprise that it is being used in various industries. Among the industries that we can really see prominently where AI is being used is industries such as the healthcare industry, finance, and retail. So, how is AI being applied in business and how do they help? An example, first of all, is the automation of tasks. So, what does this mean? Tasks that are repetitive and require manual labor are now being done by AI. So, for example, data entry or inventory management are now being done by AI, which subsequently will allow to decrease the chances of human error. A second example is decision making support. With AI being able to go through a vast amount of data in such a short period of time, it can produce and give a decision, a smarter and faster decision to business owners. And thirdly is customer service. I'm pretty sure most of us have come into contact with AI powered tools such as chatbots or virtual assistants. So business owners are now opting to use this as the first line of customer service, as it allows for them to provide customer support 24/7 to their customers. So the customers don't need to wait for the next working day for them to have an answer to their query. Now, with all that I've said just now, we can see how integrated has AI gone into our daily lives. So that is why it is important for us to understand what is the legal perspective of adopting AI and why is it necessary for us to have a regulatory framework. So first of all, let me start by giving an overview of the legal framework in Malaysia. Currently, the government has not enacted a legislation which regulates or deals specifically with artificial intelligence, unfortunately, maybe in the future. However, the Ministry of Science, Technology and Innovation, or MOSTI, recognizing the need for having a framework for the deployment of AI, has taken the proactive steps and published the national guidelines on AI governance and ethics. Now, I just want to give a disclaimer that this guidelines is not legally binding, but it acts as a mere reference. But it does encourage voluntary adoption for businesses or organizations that do use AI in their business. It has 7 principles such as security, privacy, reliability. So all of these are aimed to target different categories of stakeholders. One of them is end users. These can include individuals or organizations that use AI. Policymakers, government bodies. So this refers to government agencies or government bodies that are responsible in formulating and implementing policies or framework in relation to AI. We have developers, so developers of AI systems, technology providers, and suppliers. Moving on. So actually, at the end of last year, in December, the government has officially launched the Malaysian National Artificial Intelligence Office, or in short, NAIL. So this agency is responsible in promoting the adoption of AI, getting investments in relation to AI into the country, whilst also being responsible to frameworks, code of ethics in relation to AI. So this is in line with the government's intention of making Malaysia as the regional hub for AI development. Under this agency, they aim to pursue 7 deliverables that is supposed to be done within the next 12 months. So the 7 deliverables are those that are on the screen, which includes a technology action plan until the year 2030, a regulatory framework, the acceleration of AI technology adaptation, which means the usage of AI technology in various sectors, producing a code of ethics in using AI, producing an impact study for the government, a trend report, and data sets in relation to AI technology. Now, although I said that there was no specific legislation that governs AI specifically, there are existing legislations which may apply to the usage of artificial intelligence. So one of them is data privacy laws. Now, as we know, artificial intelligence in its very nature uses a vast amount of data for it to be able to function and operate effectively. Of course, when you are using and you're processing data, the concern of data privacy rises. So in Malaysia, the processing of data is governed under the Personal Data Protection Act 2010, or PDPA. So under this PDPA, it provides 7 principles that gives obligations to businesses and organizations that intend to process data for them to comply with. And among the 7 principles, one of them is obtaining consent. You must obtain consent, explicit consent from the individual before you are able to collect and store and process his data. Second, you must disclose what is the purpose you want to use his data for. Third, how long is the data going to be retained for? And fourth, you must ensure that there are enough security measures to ensure that there's no breach or there's no unauthorized access to maybe sensitive information. So then when AI comes into play, there's of course it raises the challenges in relation to data privacy laws. One of them is what is the purpose of the data? So as mentioned just now, AI uses a lot of data that it collects gradually to be able to function properly. So if the data has been collected for one purpose and has been disclosed to the individual for one purpose and obtained consent, it cannot be used for another purpose without obtaining further consent. But how would we know this? The second is the transparency of the usage of the data. So pursuant to the first one, if you have already obtained consent for a certain purpose to use the data, but how would we know if this data is being used subsequently for a completely different purpose without the knowledge and the consent of the individual? And lastly, the issue of data retention. So AI algorithms and the system works better over time because they can collect a lot of data to predict and to come out with the information that you want. So with this being said, we are unsure on when and how long the data that has been collected will be retained for. Next, we move on to intellectual property laws. Intellectual property laws are laws that are enacted to protect the rights of creators and inventors. So there are key statutes such as the Patents Act, the Copyrights Act, the Trademark Act. So among these key statutes, they have a common element, which is that who is the creator? There must be a creator or there must be an inventor. Now, when AI comes into play and produce the creative work, whether it's a song, whether it's an invention, the issue arises on who can be named as the inventor or the creator. Can we say that the inventor, the ownership rests on the programmer that designed the AI overall? Can we say it's the individual that has instructed the AI to produce the certain work? Or can we say that the AI is the inventor itself? So this is the question that arises in relation to intellectual property. For example, if we take in relation to patent law, so patent is a right that is conferred upon an inventor. So he can use his invention exclusively and he can exploit it commercially, and no other person can sell or copy his work. for a certain period of time. Now, what if the AI is the inventor of the certain invention? So can he be named as the inventor? So this was discussed in the case of Thaler against the Comptroller General of Patents, Trademark and Designs. So this is an English case that went all the way up to the UK Supreme Court. So in this case, Dr. Thaler has submitted an application for 2 patents, but instead of naming himself as the inventor, he has named his AI system called Davis, that's how you pronounce it, as the inventor. So when he submitted his application to the Intellectual Property Office, his application was rejected on the basis that an AI system does not fall under the definition of a natural person for it to be recognized as an inventor. So, of course, he was dissatisfied with this decision and he decided to appeal. He appealed all the way up to the UK Supreme Court, which in turn came out with the same decision and dismissed his application and found that AI system does not fall under the definition of a natural person for it to be recognized as an inventor. Now, of course, this is an English case. Unfortunately for Malaysia, we haven't gotten to deliberate on this issue yet. So it will be interesting to see whether what would our courts decide and whether we will follow the decision of Dr. Thaler. Next, we will move to contract law. I'm sure we have commonly heard that AI can play multiple roles in contract management, starting from the start till the end. It can help in drafting the contract, so it gets templates, precedents from online, and able to assist in drafting a contract according to what the individual wants. It can assist in negotiations, so it can analyze certain terms and determine whether it's a risk or not for or favorable for the certain person, for a certain party. Execution. So for a contract, there are certain contracts such as smart contracts, which is contracts that is powered by algorithm, and it has already included predetermined conditions. Predetermined conditions that once it has already been fulfilled, then the contract can be executed. So for example of a smart contract, we can take a simple example is a vending machine. So in the vending machine, you decide which item or food that you want, and then you include which number, and it will come out with a price. And then once you have paid the price according to what is stated on the screen, and then once it has gone in, and then the item will fall down and you can get it. So that is a simple example of a smart contract. And lastly, compliance, which is the AI can help to flag any breaches or non-compliance in accurate time. Although I mentioned all of this in how AI can assist in contract management, it still raises certain issues. First of all, on the issue of enforceability. Contracts such as smart contracts that are still new, it is unsure whether it is enforceable. It is being said that smart contracts, as long as it complies with the conditions under the Contracts Act 1950, which is it must be offer, acceptance, conditions, and intention to create legal relations, then there is a contract. However, to have confirmation, we are still unsure. And the issue of enforceability also arises, what if the contract that the AI drafts is not up to date with the latest legislations? So this will in turn come into the issue of liability. If the contract that the AI drafts is unclear in terms of terms, maybe the terms that is drafted, the clauses that is drafted is not what the parties intended, if it is not enforceable due to it being outdated in terms of law, so who will be liable for this? Is it the programmer who designed the AI, or is it the party that has prompted for the drafting of the agreement? And lastly, there is also the issue of insufficient customization. With AI, what they do is that they draft contracts based on previous precedents and templates that they can find online and the data. So this may not be enough to draft a contract specifically for the needs of a certain party. They are unable to foresee unforeseen circumstances that is beyond what is the data that is provided to them. Next, we move on to employment laws. We see nowadays that AI is increasingly used in the workplace for various reasons, such as recruitment, hiring, employee monitoring, and performance assessment, automation, and decision making. So with that being said, even though it is used for various reasons, it must still comply with employment laws. So, for example, if it's used in recruitment and hiring, employers might ensure that the AI tool that is being used is not susceptible to bias or discrimination. Whereas for employee monitoring and performance assessment, which may be used to maybe record the employee's attendance, you must be sure that there must be a boundary so that the employee's privacy is still being protected. The issue of automation, with some jobs being made redundant due to the fact that AI is being used to replace manual labor, employers must ensure that if, let's say, the job is being replaced by AI, it must follow the proper procedures of retrenchment. And lastly, in the issue of decision making, when the decision making is in aspects of certain things that may affect the livelihood of the employer, it is advisable that a human should oversee the decision making itself. Now we have gone over all the legal frameworks in relation to Malaysia. Allow me to touch on the international legal framework. So in July 2024, the European Union has enacted an Artificial Intelligence Act. So it is said to be the first of its kind. It's a comprehensive guide, and I'm sure it will be a precedent that will be referred to by other jurisdictions when they intend to enact their own Artificial Intelligence Act. So it aims two types of group, which is the providers of AI systems, which is like the developer, the technology providers, and then secondly, the entities that use AI in a professional context, which means businesses or organizations that use AI. So in this act, they recognize four different levels of risk that associates with AI system. There is unacceptable risk, high risk, limited risk, and minimal or no risk. So for different risks, it's completely prohibited, or there are certain requirements or procedures that has to be followed. So those are the four risks. And lastly, allow me to just touch on the types of contracts for AI adoption. So we have vendor agreements for AI technology. We will set out the quality and responsibilities related to AI services. The licensing agreement, which will govern the use of proprietary AI software or platforms. We have data sharing agreement, which will outline the terms for sharing data between parties for AI training or operational purposes. And lastly, we have terms of use for AI-driven products or services. So these agreements I just gone over briefly, but it will later be explained in further detail by my colleague Anis in the third talk. So with that being said, allow me to pass on to my next speaker, Miss Sarah.
Thank you, Mira. So I'll be talking on the accountability and liability when it comes to AI integration. So when issues arise due to AI-generated errors or outcomes, who will bear the responsibility and how it should be addressed? So accountability here means taking legal responsibility for the damages that's caused by AI. So whether that's due to errors in information used, that decision making or outcomes from AI. In Malaysia, we do have a gap in comprehensive or specific legal regulations or guidelines to govern AI, as mentioned previously by Mira. So to better understand how liability arises, let's examine how generative AI tools work and the scenarios that will illustrate the risks. So firstly, I want to give a brief background on how generative AI tools work. So generative AI systems, they create content by being trained on these massive amounts of publicly available data on the internet. So the AI tools will take the data and analyze its patterns and then learn from these data, therefore producing new sequences. However, these kind of AI systems often lacked depth understanding required when it comes to a professional legal context. So, for instance, there'll be contractual errors. Systems are not programmed to think like a person or like a lawyer, so they will lack an understanding of the implications when they use certain legal language when it comes to drafting contracts, which can then lead to misinterpretations or inaccuracies and sometimes unclear contract terms. So a contract must also meet certain formalities for it to be valid and enforceable. An AI, when drafting, may overlook these when generating the contracts, resulting in the contracts that fail to meet legal standards. Sometimes in complex cases, AI cannot assess or take into consideration of all the different aspects in the scenario, any future implications or real-world effects, which are critical when it comes to high-level legal reviews or drafting. So moving on to, there's also a liability issue when it comes to data breaches. AI systems, they remember the data inputted in the system during the use, therefore creating risks of sensitive or confidential information being misused or mishandled. The AI systems, they can retain the sensitive data to train its system, as I mentioned earlier. That's how generative AI works. So there could be possible misuse of confidential client or business data, which could breach the PDPA, which is the Personal Data Protection Act. And let me show you an example of this, where I have the first picture here, where is an example of AI systems retaining sensitive data. So this is how they retain the data. So if you haven't noticed, there's this memory function on ChatGPT, as shown in the picture. How it works is this feature allows ChatGPT to remember information from previous interactions with the user, which is you, to provide a more personalized and relevant responses. So in order for the AI system to not retain the data, you have to explicitly tell the chat to forget certain information via chat or via the ChatGPT settings. If not, then your information will be retained on the system. The next case that we will look at illustrates how there's unauthorized use of copyrighted material in order to train AI systems, and this can violate IP laws. In this case of Getty and Stability AI, remember how I mentioned the AI will take a huge set of public data and generate something new. So this is an ongoing litigation by Getty Images against the AI, alleging that its text-to-image model was trained on copyrighted images and metadata. So Getty Images claims that this deprived them from revenue from licensing the original images. So even the evidence shows distortions of the Getty watermark, which you can see in the picture. The case is still ongoing. The trial will take place this year, and the outcome of this case will have far-reaching implications. So we can see that the legal boundaries associated with generative AI is continuously being established. And then the court will consider all the novel issues and determine new precedents when the time arises. Moving on to my next point, which is misinformation. AI systems sometimes generate outputs that are inaccurate or misleading, which can lead to liability for misrepresentation. So in this one example, which is the Air Canada case, the chatbot misrepresented a bereavement fair policy to the client, which is entirely inconsistent with the airline's existing policy. The tribunal then held that the company Air Canada is accountable for negligent misrepresentation, and they emphasize that businesses cannot separate themselves from the AI outputs that's available on their platform, because these AI chatbots, AI is not a separate legal entity that can be held accountable for its own actions. They are part of the business deploying the use of the AI. Another case is the ChatGPT lawyer case. This one is in 2023, a lawyer in US relied on ChatGPT for legal research when it was a federal court lawsuit, which resulted in the submission of 6 fictitious court cases in their brief. The lawyers were unaware of it, and when asked to produce the copies of the case, they couldn't. And the judge fined both attorneys $5,000 and then dismissed the lawsuit entirely. So this case highlight a critical point where AI or ChatGPT is not a super search engine. So many users, when they use these AI systems, they don't fully understand its limitations. So you should always verify AI generated information before relying on it. Lastly, there's also the duty to warn or inform others of the use of AI. Accountability extends to the duty to warn or inform. So the developers and deployers of AI systems, they must ensure that end users are adequately informed about the risks and limitations of the technology. So failure to do so, or vague or insufficient terms and conditions, could lead to negligent claims, especially when errors or biases are produced in the system, resulting in harm. Lastly, I'll touch on allocating responsibility when it comes to AI failures. In the absence of proper infrastructure, laws, regulations, determining liability can become very complex. So, who should be held accountable? Potential stakeholders will include the developers or programmers of the AI, the people who code them, the owners of the AI system, or the deployers or companies that implement or use AI to support their business operations or customer interactions. And it can also be the end users, which is individuals who utilize the AI generated content when it comes to using it commercially. If it results in harm or infringement, the users may be held accountable for their actions, especially when they fail to verify the content's legality or accuracy. So, to address the complex issue of accountability, there can be several mechanisms put in place to ensure proper safeguards. Firstly, contractual liability. By placing explicit provisions in contracts, explicit clauses, it can help define responsibilities and liabilities in advance. So, for instance, contracts may specify which party will be held liable where for damages caused by using AI systems. Thereby, there can be clarity and reduce disputes when the situation happens. So the next one is strict liability. A strict liability approach here places responsibility on AI developers or operators for any damages caused by the system, regardless of negligence or intent. This ensures that those closest to the development and operation of the AI take every precaution to prevent harm. Next, regulatory frameworks are also essential for ensuring safety, compliance, and clear guidelines for the developers, the owners, and the deployers, which is the users of the AI, to mitigate risk and operate within the legal boundaries. Lastly, there can be insurance policies. AI liability insurance can be a practical solution to manage the risk. So, by providing coverage for the damages caused by AI systems, insurance not only protect the stakeholders financially, but also incentivize them to take reasonable precaution and adopt best practices to minimize any harm that comes from using the AI system. So that's all from me. I'll pass it on to Anis for the mitigating.
Good afternoon, everyone. Thank you for sticking around. I hope we haven't lost anyone. I'll be covering mitigating AI risks. So, from what Mira and Sarah presented, because we don't have legislation that specifically regulates AI, and there are several scenarios where liability may arise, it goes without saying that businesses must manage and mitigate against AI risk internally and proactively. Now, how you manage these risks and to what extent you have to strategize will depend heavily on the nature of your business, and it will also depend how AI is used by you in your business and at which stage of your operations these measures, again, in using AI need to be taken. So implementing proper measures is crucial for ensuring business continuity as it helps protect your company from costly lawsuits and, equally important, safeguards your reputation. So to illustrate this, let's go back to the example that Sarah mentioned, the Air Canada. Admittedly, yes, it was only a small claims court and it was only around 80 Canadian dollars, which is around 2,000 ringgit. But we have to acknowledge that the real impact was on the airline's customer service reputation, especially in its business in aviation, right? How we feel about a business and what we think, even if their policies on refunds is something that we remember, especially if it becomes as big as of news that it did. And the situation definitely tarnished a bit of its public image. So this highlights how managing risks effectively is not just about avoiding financial losses, but also about preserving the trust and loyalty of your customers. So yes, it does matter. The strategies to mitigate risk is not a one-size-fits-all kind of thing, and it requires a multifaceted approach that combines legal, technological, and organizational strategies. Notably, not all risks can be resolved through legal mechanisms, but here are some of the matters where lawyers can advise you and help you mitigate these risks. So, first of all, we can provide corporate training to build awareness about the legal risk and compliance requirements across all levels of the organization. And we can also help you structure a governance framework which establishes clear policies and accountability for AI. So it would adopt all the measures that Sarah was indicating earlier. And we can also advise you on how best to implement human oversight and periodic audits of AI processes. And our bread and butter. Reviewing contracts and for your businesses is something that we can definitely assist you on, and ensure that all the relevant terms in the contract are mentioned, as Sarah mentioned earlier. So whichever strategy you choose, it can be either or a combination of all these tools at hand on screen you see. The aim should always be to have a balanced approach. After all, we want to leverage AI as a tool while ensuring it complements your business strategies and also human judgment. Before diving into the specific strategies I'll be discussing today, I'd like to highlight just the fundamental step involved in mitigating any risk. So it all starts with identifying the risk, followed by designing the systems to minimize or avoid those risks and creating protective measures, and then continuously monitoring the system to ensure risks don't materialize or reoccur. So hopefully with this in mind, as we explore strategies today, you will see how each one aligns with different stages of this risk management process, and we will go through some examples at the end. And hopefully by the end of this session, you'll be able to assess if you have enough measures or you need reinforcements, and we can assist you. So the first strategy is usually on building is corporate training. So what corporate training aims to do is basically build awareness through training to ensure that employees at all levels understand the risks and responsibilities associated with AI. Among the main steps to build awareness, if you think about the ChatGPT incidents, reputations could have been spared if they were only informed from the beginning of what AI was capable of. Like, it was capable of lying about cases and making up cases. So if that education had existed before anyone started using the ChatGPT, then their reputations could have been spared. And they could have also, done the due diligence to check that all those cases exist. So the businesses need to roll out training for everyone in the team, from top management to employees, and we can assist you by developing tailored training programs that align with specific legal obligations and operational needs of your business. So what would this training include? It would include sort of the key components of effective AI training. First of all, it would definitely be allowing you and your team to understand existing legal framework and regulatory changes. So I think Mira mentioned how PDPA is often the focal point in terms of AI risk, because AI at its core is basically processing a lot of data, whether that's personal data or all the information available online, or whether it is AI used internally to assess any of your systems. So a key component, if we have corporate training, would be to understand how the PDPA applies to your business, whether it applies, and also understanding the upcoming changes. So if you may be aware that certain amendments have been introduced for the PDPA. It was gazetted last year in October, and a few of its provisions have been enforced starting this year. But the main changes on its data notification and appointing a data officer, those things are going to be effective in June. So now is a great time to consider these aspects, and we can effectively train for you to be able to transition into when those provisions would be fully enforced. One of the most effective ways to ensure that once we inform you of all these updated laws and everything, how we ensure employees fully grasp corporate compliance is through our scenario-based training. So this approach allows participants to engage with real-world situations that they might encounter in their respective roles. So it could be over a one-day thing, or it could be a very specified group sort of exercise, depending on the role and the team they come from, and presenting them with specific scenarios for them to act on and improve the decision making. And following from that training would definitely be monitoring the employees so that they would be able to implement this knowledge and recognize non-compliance issues. And this includes understanding the key indicators of potential breaches and knowing how to report concerns appropriately. In addition to that, we also have interactive workshops, which involve role play sessions, which allow employees to effectively practice their response to whatever compliance issues we put as a scenario. And we allow them to be able to, take the approach as a regulator and also as the one being regulated. So you can see how different roles intertwine with each other and how the entire team needs to work together to make sure that the organization is consistently in compliance. Another strategy to mitigate AI risks is through establishing clear governance frameworks with defined objectives, scope, and roles. So there are various tools to help businesses establish a clear and actionable governance structure. This may include all the template governance policies, defining each person's respective role and the responsibilities they have in the implementation and adoption of AI in your businesses. So this could also entail checklists for identifying and mitigating AI-related risks, mandatory contractual clauses, which we'll address later on, and creating guidelines for coordinating and collaborating between legal, IT, and operations teams. There are numerous measures also which will fall under oversight mechanisms, and these help the organization maintain transparency and accountability in implementing trust in AI systems. So this would entail establishing interdisciplinary AI committees, and this is basically the introduction of human oversight to the process. So I know that, the very reason we rely on AI most of the time, as Mira mentioned, is basically things that don't need human input, right? But in order to minimize these risks, such human element is still required. So they are there to ensure that the decisions are not made solely by AI where appropriate. Next is maintaining transparency. This is achieved through detailed documentation and the documentation of AI decision-making processes. And the reason why clear and consistent records are required is because this would facilitate internal reviews as well as external audits. And the focus that most people are using as a mitigating factor these days is incident reporting protocols. And this is in line with the recent introductions to PDPA, which makes it mandatory for some data controllers to notify the authorities when there has been a data breach. So incident reporting is something that a lot of businesses are looking into in quite detail these days. And lastly, engaging external experts is another tool as an oversight mechanism, and engaging third parties to evaluate systems periodically and objectively. And the last strategy or method that we can use to mitigate risk is obviously to contractual terms. So what this means is incorporation of certain clauses. So Mira pointed out the various types of contracts that can be used to mitigate AI risk. I'll demonstrate them later, but because it is so how your strategy is devised based on your business structure, it's very hard to say which one is suitable for your business. But looking at the type of clauses that we can implement, these are clauses that can be implemented not in just one contract, but in all the contracts that you may use for your business activities. The one that I wanted to highlight here is definitely defining the AI. So defining the AI and machine learning systems would be very important, especially in the Air Canada cases, because with that definition and delineation, we understand the purposes and limitations of the AI that's being used. So if in that sense, when the airline was using the chat, if it was mentioned somewhere that this chat box was not pulling information from the policies, then that risk could have been avoided. So defining it properly and ensuring your team understands the purpose of the AI and the limitations of that AI would enable the team and other stakeholders to understand what the AI entails, and it would manage expectations, ensuring that the operational aspects align with the defined technologies utilized. And another thing I wanted to highlight was termination clauses. So these are clauses you can incorporate into your contracts or going into contracts where you make it a condition for them to, if AI is heavily relied on for any business transaction, they would need to define whatever risks that need to be addressed. And if not addressed, it would have to be grounds for any party to terminate the contract. So this would entail, setting out the triggers, so such as data breaches, unmet performance standards, or even non-compliance with regulations, which is quite standard. So I think I've covered most of the points that I wanted to highlight, but before I conclude, I wanted to revisit the basic steps that I mentioned earlier. So each step here corresponds to a key component in the process. For example, strategies like corporate training and governance framework fit into the design aspect. But as you can see, this step can't be proceed to the second step without understanding, identifying the risk that's involved. So once we've identified the risk and we design the system, we can then focus on the protection and oversight mechanisms. So our main role is usually in assessing the risk and recommending the protective measures. So I basically put examples based on the ones that Sarah had gone through earlier. So for contractual errors, which are identified, the protective mechanisms which we normally utilize is the legal review and due diligence. And for data breaches, what we address this by including specific terms in contracts to clarify responsibility. So this would mean defining whether it's such data breaches falls on the company or the employee. And depending on where they are outlined, we can either utilize employment contracts or internal policies. And in the case of misinformation, as seen in the Air Canada example, we would recommend implementing a terms of use policy for AI tools similar to the consent terms of use boxes you encounter online when you use any website. And the last part would be monitoring. So this is where the risk assessment comes in, and also additional training and doing the drills and scenario-based training. This actually provides a very brief overview of the process. It's actually very detailed in practice, because obviously you would identify the risk based on your own your business and what sort of business activities you are involved in day to day. As a concluding point, I think it's important to recognize that AI is a tool designed to enhance human capabilities and not a replacement. And since Malaysia is still in the early stages of establishing a comprehensive AI framework, businesses must take an active role in the AI governance and compliance efforts through strong collaboration across all levels of the organization and through training to equip the teams with the skills needed to embrace response. And I think with that, I can pass the floor back to our moderator, May.
Thank you, Ms. Anis, Ms. Mira, Ms. Sarah, for sharing your valuable insights on the legal considerations of AI in business today. We will now address questions from the participants in the Q&A chat box. I see we have a few questions. First one we have is, what are the laws or standards or regulations for Malaysian AI developers to comply with? I think for this question, can I pass this to you, Ms. Mira?
Yes, can. Thank you, Amir. So the question asks, what are the laws, standards, regulations for Malaysian AI developers to comply with? Okay, this is very comprehensive. First of all, we will have to know what is the AI being developed for, what is the purpose? Is it to produce certain intellectual property works? Is it going to be used in healthcare? So we can't give a definite answer on what are the laws, what specific laws have to be followed, but the general overview that will have to be followed include such as the PDPA, like I mentioned just now, which regulates regarding processing of personal data, intellectual property laws. Let's say the AI is used for that purpose, there will be needing an agreement which will set out the terms on who the ownership relies on, who the ownership is given to. We also have ethical guidelines, although it may not be binding, but it is meant to be referred to. We also have the cybersecurity laws, Cybersecurity Act 2024, and also there is other frameworks such as the National AI Roadmap and all the factors of ESG. So I know seems like a lot, but we would need to know in better detail on what is it that the AI is developing, what is the system for, before we can advise further. Thank you, Ame.
Thank you very much, Ms. Mira. For our next question, this one is from an anonymous attendee. If the data we use for AI systems does not involve any personal data like name, contact details, etc., will data privacy law or PDPA still apply? I think for this one, I'll pass this to you, Ms. Sarah.
Thanks, Ame. So PDPA is Personal Data Protection Act. So PDPA does not apply to data or information used by a data user that does not identify as individuals, i.e. data subjects. But when it comes to copyrighted creative works such as pictures, drawings, articles, then one can be held liable for infringement under IP laws instead.
Thank you. For our next question, since the decision by our AI system cannot be treated as separate entity, can we ensure that AI decisions using insurance like professional indemnity insurance? I think, would you kindly take this one, Ms. Anis?
Yep, thanks, May. So professional indemnity insurance providers, such as those for lawyers, specifically exclude the use of AI in some cases. So risk assessment and management strategies are required to be in place by the firm. AI risk can be covered under personal indemnity insurance. So there's no specific regulation on the use of AI under PII schemes presently. So it is the firm's responsibility to ensure responsible use of AI systems within the firm as mitigation and reduced risk. So I will add that our firm itself have implemented training trainings to allow and empower our teams to use AI responsibly. So this talk actually applies to both legal practitioners and business owners as well. Yeah, whichever sector you're in, definitely it's on yourself to ensure responsible use of the AI systems.
See, we only have a few minutes left for today's session. So I think we'll be taking one last question from the Q&A chat box. This is also from another anonymous attendee. Does EU AI Act apply to Malaysian company, but users include European residents? Is it similar to the EU GDPR? I think I'll pass this one to Ms. Mira.
Okay, thank you, Amir. So the EUA Act sets out the parties which the Act will apply to. So it is divided into three different parties. So the first one is which any provider placing an AI product or service within the EU. The second one is the users of the AI products and services is within the EU. And thirdly, which is any provider or user of the AI system where the output produced by the system can or is intended to be used within the EU. So based on your question on whether if, let's say, the Malaysian company has produced an AI, but it is used by European residents, I believe it would fall under the second category, which is the users of the AI product is within the EU. So as such, it would assume that the EU AI Act will apply. I hope that answers the question.
All right. Thank you again to all our speakers today. Now, before we conclude today's session, I do have a few announcements to make on behalf of the firm. First, please do join us again for our upcoming talk. This will be held on the 22nd of January, which is in a couple of weeks. It will be on purchasing properties from developers or through subsale, key differences and considerations, and will be conducted by our Misters Vincent Cheng and Kairo Hakimi. Secondly, as always, we have a feedback form for today's session. So please do let us know what you thought of our talk. The link to the form will be posted in the chat. Thirdly, feel free to follow or like our social media accounts. We are on YouTube, Twitter, Instagram, LinkedIn, and Facebook. Fourthly, if you would like to speak with any of our lawyers, we do offer a complimentary consultation of up to 30 minutes over the phone or over video conference. To do so, please fill in the form on our website. The link also is posted in the chat box. And that's all for today's talk. Thank you very much to all our guests for joining us. And as always, we hope you found today's session informative and useful. Thank you again, and see you at our next session.